We have some pretty big news coming out of VA land this week. The U.S. Court of Appeals for the Federal Circuit issued a ruling in the Procopio v. Wilkie case on January 29th. And it's a pretty big deal for Vietnam veterans, specifically those veterans who are referred to as the Blue Water Navy veterans. They determined that Blue Water Navy veterans who served within the 12 nautical mile territorial sea off the coast of Vietnam, that they qualify for presumptive service connection for diseases that are related to herbicide exposure. And let me give you a little bit of a background first to explain why that's a big deal. Back in 1991, Congress passed the Agent Orange Act, and that allowed Vietnam veterans who served in the Republic of Vietnam to get presumptive service connection for a whole host of diseases that are related to herbicide exposure. There's certain diseases like diabetes mellitus type 2, prostate cancer, lung cancer, ischemic heart disease. Those diseases and several others have such a high correlation of being related to herbicide exposure that if you were a veteran who served in the Republic of Vietnam between 1962 and 1975, VA gave you presumptive service connection for it. And so Congress, by passing this act, allowed VA to do that. VA then, as it's supposed to do, issued regulations, and they also had their attorneys, their Office of General Counsel, issue some opinions on what exactly that means and what veterans are included in that group. And so they previously had it where a veteran was considered to have served in the Republic of Vietnam if he or she had boots on the ground. So you had to have set foot on the land mass of Vietnam itself, or if you served in the inland waterways. So the shallow inland waterways are considered part of the Republic of Vietnam. And for those veterans who served on ships that went up and down the inland waterways and patrolled it, they were able to be getting, they were granted presumptive service connection as well. However, who was left out of this was the what are called Blue Water Navy veterans who served in the blue or the deep waters that were off the coast of Vietnam. So they were still in the territorial waters of Vietnam, but they were off the coast of it, or they served in the harbors. So Da Nang Harbor, even though you're surrounded on three sides with the country of Vietnam, those veterans weren't given presumptive service connection because they were considered to be in blue water, it was deep water, and they weren't able to get service connected for any of the presumptive disabilities that are related to herbicide exposure. So this case is a really big deal because the veteran in this case, Mr. Procopio, he served on one of the ships that were off the coast of Vietnam, and he was in the right place at the right time. He was there, I believe, in 1964, so he met the 62 to 75 requirement. But the problem was he was in the ship off the coast of Vietnam. And so he sued and said that Congress, when it wrote the act and said the Republic of Vietnam, it meant to include the territorial waterways, because any country that is surrounded by the ocean, even the U.S., you have part of your country goes into the ocean. So you have U.S. waters. That's why you'll sometimes hear on the news that ships were found in U.S. waters. Same thing happens with Vietnam. There's 12 nautical miles that goes off the coast of Vietnam that's considered to be what is called the Republic of Vietnam. And so that's what Mr. Procopio was arguing in this case. He was saying because he was in that area of the water, he should be considered as serving in the Republic of Vietnam, and that's what Congress meant. That was his argument. And so he should get presumptive service connection. And in this case, the Federal Circuit agreed with Mr. Procopio and said that indeed that's what Congress meant. When it said the Republic of Vietnam, it didn't mean to exclude anyone who served in the territorial waters. It meant to include all of those people. And so this is a really big deal for all Blue Water Navy veterans because they're now finally able to get service connection for all of the diseases that are related to herbicides. We don't really know quite yet how it's going to play out at VA. VA still has a time period where they can appeal the decision up to the U.S. Supreme Court, so they could do that. If they do that, then this case is going to be put on a stay, and so nothing's going to be implemented while the Supreme Court is listening to the case and waiting to make its decision. If that doesn't happen and the VA doesn't appeal it up to the Supreme Court, then it's going to be implemented at VA. They'll issue new regulations around it, and all the cases that were previously decided can then be brought up again, and the veterans can argue that they should get presumptive service connection. So as you can see, it's a huge deal, makes a big change in the way things have been handled for the Vietnam veterans, and they've been waiting for this decision for quite a long time and arguing for it. So it's a big deal and really important that we wanted to let all of you guys know about.